Disclaimer: the content provided on this channel is for general informational and educational purposes only. It is not legal advice. I am not a licensed attorney. Viewing this content, commenting, or engaging in any communication with the creator of this channel does not create an attorney-client relationship, nor is any communication considered privileged or confidential. The law is complex and varies significantly by jurisdiction. The information presented may not be applicable in your specific state or country. For advice on your individual legal situation or issue, you must consult with a licensed attorney in your jurisdiction. Do not act or refrain from acting based on the content of this channel.
Strategic guide drawn from years of experience, designed to give you power and control in a difficult situation. For legal advice specific to your case, you absolutely must consult with your own qualified attorney. Imagine this. You get a letter in the mail. It's not a bill, it's not junk mail. It's thick, heavy, with the name of a law firm in the top left corner. Your hands feel a little cold as you open it, and then you see the word. A word you've probably heard on TV shows, but never thought you'd see with your own name attached to it. Subpoena. And right there, in black and white, it says you are required to appear for a deposition. Your stomach drops. Your mind starts racing a million miles an hour. A deposition? Me? What did I do? What is this about? What if I say the wrong thing? Am I going to get in trouble? Could I lose my job? My house? My reputation? Suddenly, you feel completely powerless, like you've been dropped into a game where you don't know the rules, you don't know the players, and you don't know the stakes. This video is your rulebook. This is your survival guide. This is the crash course your own lawyer might be too busy or too expensive to give you. We are going to pull back the curtain on the entire deposition process. By the time you finish this video, you will not only understand the game, you will know how to play it. You will learn the traps that are set for you and exactly how to step around them. You will walk into that conference room not with fear, but with confidence. You will trade anxiety for strategy. So let's start with the most important question. What even is a deposition? Because what you think it is almost certainly wrong. And that misunderstanding is the first trap. A deposition is not a conversation. It's not a friendly chat. It's not a chance for you to tell your side of the story and convince the other side that they're wrong and you're right. I'm going to say that again because it is the most critical lesson you will learn. A deposition is not your chance to tell your story. Trying to do so is like trying to win a fistfight by giving your opponent hugs. It will not work. A deposition is also not a trial. There is no judge. There is no jury. No one is going to rule on who is right or wrong at the end of the day. The entire purpose of a deposition is for the other side, the opposing counsel, to gather information. That's it. It is a fact-finding mission. For them, not for you. Think of it this way. The lawsuit is a war. The deposition is the other side sending a spy deep into your camp to map out your defenses, count your weapons, and test your weaknesses before the big battle. You are the territory they are exploring. The lawyer asking you questions is that spy. And every single word you say is another piece of their map. Your only job is to give them the most limited, boring, and unhelpful map possible, while still telling the truth. There are three primary goals the other lawyer has. First, they want to know what you know. They want to discover all the facts, good and bad, that you have in your head. Second, and this is crucial, they want to lock you into your story. They want to get you on the record under oath saying the sky was blue, so that months or years later at trial, if you say the sky was a bit overcast, they can wave that deposition transcript in front of a jury and say, "Ladies and gentlemen, this witness can't even keep their story straight about the sky. How can you believe anything else they say?" It's a perjury trap. And third, they want to see what you're like. Are you nervous? Are you confident? Are you easily angered? Are you sympathetic? They are sizing you up as a witness to see how you'll play in front of a jury. They are testing you. To navigate this, you have to understand the three people in that room and what their real jobs are. First, there's the opposing counsel, the questioner. This person may be polite. They may be charming. They may offer you a water or a coffee. Do not be fooled. They are not your friend. Their job, their one and only job in that room, is to build their case and destroy yours. Every question they ask is a tool designed for a specific purpose. Some questions are like shovels, meant to dig for new information. Some are like hammers meant to break down your credibility. And some are like scalpels designed to surgically extract a single damaging admission. They are a professional, highly trained conversational tactician whose sole purpose is to get you to say things that will benefit their client. They are your adversary. Full stop. Second, there is your lawyer, your defender. Your lawyer is your shield. But here's something most people don't get. Your lawyer's job in a deposition is not to answer questions for you. In fact, they will say very little. And you should be thrilled when they do. When your lawyer speaks, it's usually to say one word: objection. That word is music to your ears. An objection is your lawyer officially telling the other side, hey, that question is unfair. It's improper. It violates the rules. They are planting a flag for the judge to review later. Sometimes they'll object to the form of the question. Maybe it's confusing or assumes facts that aren't true. Sometimes they'll instruct you not to answer at all, but this is rare. Your job when you hear your lawyer object is simple. Stop talking immediately. Close your mouth and wait for their guidance. They are protecting you. Let them do their job. And third, there's the court reporter. The court reporter might be the most underestimated person in the room. They are not a secretary. They are a highly skilled professional creating the official legally binding record of everything that is said. They are a human recording device. They are neutral. They are not on your side. They are not on the other side. They are on the side of the transcript. They type every single word, every nervous laugh. They record your stutters. They record your long, agonizing pauses. They cannot record a nod or a shake of the head. You must answer verbally. This is why you must be incredibly deliberate with your words. The transcript doesn't capture your good intentions. It doesn't capture your sarcasm or your tone. It captures only the cold, black and white text. And that transcript can and will be used to attack you later. The court reporter is the reason why the single most important rule of any deposition exists. This brings us to the golden rule. If you remember nothing else from this entire video, remember this. The golden rule of a deposition is: listen to the question, understand the question, and answer only the question that was asked. Nothing more, nothing less. This sounds so simple. It is the hardest thing you will ever have to do in a professional setting. Why? Because it goes against every social instinct we have. We are trained from childhood to be helpful, to be cooperative, to explain ourselves. If someone asks you a question, you don't just give the bare minimum answer, you try to help them understand. You volunteer information. You provide context. In normal life, this makes you a good person. In a deposition, it makes you a good target. Every extra word you provide is a free gift to the other side. It's an unforced error. It's a thread they can pull on that might unravel your entire case. Let me give you the classic simple example. The opposing lawyer asks you, do you know what time it is? A normal human response would be, oh sure, it's about 2:15. Man, I'm a little worried I'm going to be late picking up my kids from soccer practice at 3 o'clock. What did you just do? You answered the question yes, but you also volunteered 3 new pieces of information for free. 1, you have kids. 2, they play soccer. 3, you have a hard stop at 3 p.m. and are feeling anxious about it. Now the lawyer knows they can press you on questions about your family, and they know if they drag things out until 2:55, you'll be stressed, agitated, and more likely to make a mistake just to get out of there. You gave them ammunition for free. Now let's try it again using the golden rule. The lawyer asks, do you know what time it is? Your answer, yes, that's it. You have truthfully and completely answered the question asked. You have not been rude. You have not been evasive. You have been precise. Now you wait. You sit in the silence. The silence is a tactic. It's designed to make you uncomfortable, to make you want to fill it by talking more. Don't let the silence hang in the air. It is the lawyer's job to ask questions. Let them do their job. Eventually, they will have to ask the follow-up. What time is it? Your answer, it is 2:15. You see the difference? You gave them nothing extra. You controlled the flow of information. This is the entire game. It's a game of inches and every word matters. Your mantra in that room should be, answer the question, and then shut up. Now, that silence you create after you answer, it's going to feel awkward. It's going to feel uncomfortable. It's designed to. Human beings are conditioned to fill a void. When there's a quiet moment in a conversation, we naturally want to jump in, to elaborate, to clarify, to help. The opposing lawyer knows this. They are counting on it. They will ask you a question. You will give your short, truthful answer, and then they will just sit there. They will stare at you. They won't write anything down. They might look at you over the top of their glasses, a little confused, as if they're waiting for the rest of the answer. This is a tactic. It's a classic old as the hills lawyer trick. They are using silence as a weapon to make you uncomfortable, to make you think, oh, maybe I didn't give them enough information. Maybe I should explain myself. And the moment you think that, you've lost the game. The moment you decide to help them by elaborating, you start giving away free information. You start volunteering details they never asked for, opening doors to new lines of questioning they never would have thought of. Your lawyer will have prepped you for this. They'll tell you to get comfortable with the silence. Embrace it. Let it hang in the air. It's not your job to fill it. It's the other lawyer's job to ask the next question. Let them do their job. You just sit there calm and composed until they do. This leads us to the second pillar of survival: listen. I mean, really listen. This sounds simple, but in the high-pressure environment of a deposition, it's one of the hardest things to do. Your adrenaline is pumping. You're nervous. You're trying to anticipate where the questions are going. And because of that, you stop hearing the actual words being said. You hear what you think they're asking, or what you're afraid they're going to ask. You must train yourself to listen to the question, the whole question, and nothing but the question. Don't start formulating your answer while the lawyer is still talking. Wait for them to finish completely. Take a breath. Process the exact words they used. Is it a yes or no question? Is it asking for a specific date? Is it asking about a specific conversation? Lawyers are masters of language. They craft questions with surgical precision. A single word like all or never or always can completely change the meaning of a question. Let's imagine a scenario. You're in a deposition for a workplace dispute. The lawyer asks, "Did you talk to all your coworkers about the incident?" Your brain might immediately jump to, "Well, I talked to Bob and Susan and Maria." And you might be tempted to say yes. But did you talk to all of them? Did you talk to Frank in accounting, who sits in a different building? Did you talk to the security guard at the front desk? Probably not. The technically correct, and therefore only, answer is no. If you had said yes, the lawyer now has you on record under oath saying you spoke to everyone. They will then spend the next hour bringing up every single employee you didn't speak to, making you look either foolish or worse, dishonest. So, Mr. Johnson, you didn't speak to Frank in accounting? But a moment ago, you swore under oath you spoke to all your coworkers. Can you help the court understand this discrepancy? You see how that works? It's a trap, and you walk into it not by lying but by not listening. So rule number 2, listen to every single word. If you don't understand the question, don't guess what it means. Just say, "I'm sorry, I don't understand the question. Can you please rephrase it?" You can ask them to rephrase it a dozen times if you need to. It's better to seem slow and careful than to be fast and wrong. This brings us to the third and arguably the most important golden rule. Never ever guess. I want you to burn this into your memory. If you do not know the answer to a question, there are only 2 acceptable responses. I don't know, or I don't recall. That's it. Let's go back to our car accident. The lawyer asks, "How fast were you going at the moment of impact?" Now you were driving. You know you weren't speeding. You feel like you were probably going around the speed limit, which is 30 miles per hour. So you think, 30 sounds about right. And you say, "I was going 30 miles per hour. You have just committed a catastrophic error. You didn't look at your speedometer at the exact moment of impact, did you? Of course not. You were busy trying not to get into an accident. So when you said 30 miles per hour, you weren't stating a fact you knew. You were guessing. You were trying to be helpful." Fast forward 6 months. The case is now in front of a jury. The other side's accident reconstruction expert takes the stand. He's got charts and diagrams. He says, based on the length of the skid marks, the vehicle's final resting position, and the crush damage, we calculated the plaintiff's speed at the moment of impact to be 42 miles per hour. Now the lawyer puts a giant projection of your deposition transcript up on the screen for the jury to see. He points to your answer. "Ladies and gentlemen of the jury, on January 12th, Mr. Smith swore an oath to God to tell the truth. And on that day, he said he was going 30 miles per hour. The science, the evidence, tells us he was going over 40. He wasn't just mistaken. He was lying. Under oath. And if he was willing to lie about his speed, what else in his testimony is he lying about? Your credibility is completely destroyed. And you weren't even trying to lie. You were just trying to be helpful by guessing." The correct answer to that question was, "I don't know." Or, "I don't recall looking at my speedometer, so I can't say for sure." That is a 100% truthful, 100% bulletproof answer. There's a difference between a guess and an estimate. An estimate has a basis. If the lawyer asks, "About how fast were you going?" you could say, "I wasn't looking at my speedometer, but I was keeping up with the flow of traffic, which felt like it was around the speed limit." See the difference? You've provided a basis for your answer, the flow of traffic, and you've qualified it by stating you aren't certain. A guess has no basis. It's just a number you plucked out of thin air. The phrases "I don't know" and "I don't recall" are your most powerful weapons in a deposition. Do not be afraid to use them. People feel this pressure to have an answer for everything. We're taught in school that not knowing the answer is a failure. In a deposition, it's a sign of intelligence. It's a sign that you respect the oath you took to tell the truth. You can only testify about what you personally saw, what you personally heard, and what you personally know. If a piece of information doesn't fall into one of those categories, your answer is, "I don't know." Don't let the lawyer bully you into a guess. They'll try. They'll say things like, "Well, give me your best guess," or "Just give me a ballpark." Your response should always be, "I'm sorry, but that would be a guess, and I'm not comfortable guessing under oath." Repeat it like a broken record. Your own lawyer will be beaming with pride. Finally, let's talk about the wolf in sheep's clothing. The friendly lawyer. The lawyer deposing you might be the nicest person you've ever met. They'll start by offering you a coffee or water. They'll ask you about your family, your hometown, your favorite sports team. They'll smile. They'll make jokes. They will do everything in their power to make you feel relaxed and comfortable, to make you feel like this isn't an adversarial legal proceeding, but just a friendly chat between two reasonable people. This is the single most dangerous trap in the entire process. That lawyer is not your friend. Their job, their sole purpose for being in that room, is to get information from you that will help their client and hurt you. Period. The friendly chat is a calculated performance designed to lower your guard. When we feel comfortable with someone, we get chatty. We volunteer information. We stop thinking about every word. We start treating it like a conversation instead of sworn testimony. He'll ask, "So, you were on your way to pick up your kids from soccer practice?" A seemingly innocent, friendly question. You reply, "Yeah, I was actually running a little late. Little Timmy had a big game and I was trying to get there for the end of it." What have you just done? You've just admitted you were in a hurry. You've just given the lawyer a motive for why you might have been speeding or run that yellow light. A completely innocent, conversational detail becomes a weapon they will use against you. He didn't ask if you were late. He didn't ask why you were in a hurry. He asked a simple question, and you volunteered the damaging information for free. The correct answer? Yes. That's it. Remember the first rule. Answer the question and then shut up. It doesn't matter how nice the lawyer is. It doesn't matter if you went to the same college or root for the same team. In that room you have one friend and one friend only. The lawyer sitting next to you, the one you hired. Everyone else is the opposition. Treat them with courtesy and respect, but never, ever forget that they are not on your side. Maintain your discipline. Stay formal. This is not a coffee klatch. It's a legal minefield, and the friendly lawyer is just trying to get you to take a wrong step. It's about understanding the fundamental rules of the game. Forget everything you know about normal conversation. Normal conversation is designed to build rapport, to share information, to be helpful. A deposition is the exact opposite. Your goal is not to be helpful. Your goal is to be a rock. Immovable. Precise. You give them nothing they don't explicitly ask for and are entitled to. The first and most important rule, the one that will save you more than any other, is the golden rule of the pause. When the opposing lawyer asks you a question, your natural instinct is to answer immediately. That instinct is your enemy. You must fight it. You must force yourself to take a deliberate pause before you say a single word. 3 to 5 seconds. It will feel like an eternity. It will feel awkward. The lawyer might lean in trying to rush you. Let them. The silence is your territory. You own it. Why is this pause so powerful? 3 reasons. First, it gives you a moment to actually process the question. Did you understand every word? Was it a compound question? Was it based on a false premise? Your brain needs a second to catch up and analyze the threat. Second, and this is critical, it gives your lawyer a chance to object. Your lawyer is your shield. If the opposing counsel asks an improper question, "What were you thinking that day?" Or "Did you talk to your lawyer about this?" Your lawyer needs time to jump in and say, "Objection." If you answer instantly, you've waived that protection. The damage is done. The pause is your lawyer's window of opportunity. Third, it completely changes the rhythm of the deposition. The opposing lawyer wants to get you into a rapid-fire, conversational flow. They want you comfortable, relaxed, and chatty. The pause shatters that rhythm, puts you in control of the pace. It signals to them that you are careful, deliberate, and not going to be pushed around. It is the single most powerful nonverbal tool you have. Now, after you've paused, what comes next? You listen. You really listen to the question that was asked. Not the question you think was asked. Not the question you wish was asked. The exact words that came out of their mouth. Lawyers are masters of language. They will use subtle wording to box you in. Your job is to listen to every single word and answer only that specific question. This brings us to the three most beautiful answers in the English language. Yes, no, and I don't know. That's it. For a huge percentage of the questions you face, one of these three answers will be sufficient and, more importantly, correct. Let's say the lawyer asks, "Were you at the corner of Main and First Street at noon on Tuesday?" If you were, the answer is yes. It is not, "Yes, I was on my way to pick up lunch and I saw my friend Bob and the traffic was terrible." No. The answer is yes. Period. End of story. Let them ask the next question. Every extra word you volunteer is a gift to the other side. It's a new thread they can pull on. It's a new door you've just opened for them to explore. Don't do their job for them. If they want to know who you saw, let them ask, "Who did you see?" If they want to know about the traffic, let them ask, "What were the traffic conditions?" Don't build the bridge for them. Make them lay every single brick themselves. Now let's talk about the most underutilized and powerful of the three answers. I don't know. Or its close cousins, I don't remember. Or I don't recall. People hate saying this. We're conditioned from childhood to know the answer. We think saying I don't know makes us look stupid or evasive. In a deposition, it makes you look honest and careful. Your memory is not a perfect video recording of your entire life. It is perfectly normal to not remember the specific details of a conversation from 3 years ago, or the exact speed you were traveling at a particular moment. The opposing lawyer will try to make you feel uncomfortable with this. They'll say things like, "Well, it was a pretty important day. Are you saying you don't remember anything?" Don't take the bait. Your answer is, "I don't recall that specific detail." They might push, "Well, give me your best guess." This is a trap. A huge flashing neon sign trap. Your answer to any request for a guess or an estimate is always the same. "I'm not going to guess." That would be speculation. Repeat it like a mantra, because the moment you guess, the moment you say, "Well, I guess it was around 50 miles per hour, that guess is now transcribed into the official record as your sworn testimony. They will treat your guess as a fact. Never ever guess. If you do not know for sure, the only truthful answer is, "I don't know." Let me give you the classic law school example of how this works. The opposing lawyer holds up their watch and asks, "Do you know what time it is?" The average person trying to be helpful will look at the clock and say, "Yes, it's 2:30. Wrong answer. That's not what they asked. They asked, "Do you know what time it is?" The correct, truthful, and strategically brilliant answer is, "Yes." That's it. You have answered their question completely and truthfully. Now they are forced to ask the next, more specific question. What time is it? This might seem like a silly, petty game, but it illustrates the most important principle of a deposition. You are not there to help. You are there to provide truthful answers to the precise questions asked, and nothing more. Don't do the work for them. This becomes even more critical when they start handing you documents. They'll slide a piece of paper across the table, an email, a contract, a report, and say, "I'm showing you what's been marked as Exhibit 14. You wrote this email, correct?" Do not answer immediately. Pick up the document. Take your time. Read the entire thing, from the line to the very last word of the signature block. Even if it's 10 pages long. Even if the lawyer is sighing and tapping his pen. This is your right. You cannot be expected to testify about a document you haven't fully reviewed. They are counting on you to glance at it, say, "Yeah, that looks like my email." And then they will grill you on a tiny phrase in paragraph 7 that you didn't even see. Read the document. Then once you have read it, you can answer the question. "Yes, I wrote this email." They'll then ask, "Now if you could turn to page 3, paragraph 2, it says the project was a complete success. Is that what it says?" Your job is not to interpret. Your job is not to agree with the statement. Your job is to be a reading machine. Look at the document. Find the sentence. The correct answer is, "Yes, it says that." Or, Yes, that is what the document says. You are testifying about what is on the paper, not whether the statement itself is true in a broader context. They will try to get you to adopt the document's language as your own present-day testimony. Don't fall for it. Stick to what is on the page. If they ask, "So the project was a complete success, correct?" That is a different question. That question is not about what the document says. It's asking for your opinion now. You have to recognize that shift. Answering that requires a whole new level of caution, which we'll get into. But for now, remember, when it comes to documents, read them fully and only testify to what they physically say. So let's recap the core survival tactics. 1. The pause is your superpower. Use it after every single question. 2. Listen to the question like your life depends on it, because in a legal sense it might. 3. Your best friends are yes, no, and I don't know. Use them. 4. Never ever guess or speculate. And 5. When you're given a document, read every word before you say anything. Mastering these 5 simple rules is not just about defending yourself. It's about taking control. It's about turning the tables and making it clear that you will not be manipulated, you will not be rushed, and you will not hand them the rope they need to hang you with. And the first step to taking that control is understanding the minefield you're about to walk into. Because a deposition isn't a conversation. It's a carefully constructed series of verbal traps, laid by an expert, designed to make you stumble. The opposing lawyer isn't your friend. They're not there to get your side of the story. They have one job and one job only: to extract information that benefits their client and damages you. And they do this by using specific, time-tested questioning techniques that are designed to confuse, exhaust, and manipulate you into saying things you don't mean. Let's talk about a guy named David. David was a good man, a project manager at a construction company for 15 years. He got pulled into a lawsuit over a building project that went over budget. It wasn't his fault, it was a supply chain issue, but his company was being sued, and he was a key witness. David walked into his deposition feeling confident. He thought, "I'll just tell the truth. The truth will set me free." He had no idea he was walking into an ambush. The opposing lawyer, a slick guy in a $1,000 suit, smiled warmly. He offered David a water and said, "David, thanks for coming in. We're just here to understand what happened. Why don't you start at the beginning and just tell me everything you remember about the project from day one?" And right there, David fell into the first trap. The narrative trap. This is the most common opening gambit. Tell me everything. Walk me through your day. In your own words, what happened? It sounds friendly. It sounds open. It feels like an invitation to tell your story. It is the single most dangerous invitation you will ever receive. When David heard that, he relaxed. He started talking, and talking, and talking. For nearly an hour, he recounted every meeting, every email, every phone call, every frustration. He thought he was being helpful. He thought he was building a case for himself, showing how diligent he was. What he was actually doing was handing the enemy a complete map of his territory. He mentioned names of people the lawyer had never heard of, opening up new avenues of investigation. He brought up minor frustrations and off-the-cuff comments he'd made months ago, which the lawyer scribbled down furiously. He tried to guess at dates and times, and sometimes he got them slightly wrong. He offered his opinions, his theories, his feelings about the project. By the end of that hour, David had given the lawyer dozens of tiny new threads to pull on. Hours later, the lawyer would come back to those threads. "David, you said earlier you thought the supplier was dragging their feet. What did you mean by that? Who else thought that? Did you put that in an email?" Suddenly, David's casual opinion was being treated as a factual statement. "David, a moment ago you said the meeting was on a Tuesday, but your calendar says it was a Wednesday. Were you mistaken then? Or are you mistaken now?" A simple memory slip was now framed as a potential lie. The antidote to the narrative trap is brutal simplicity. When a lawyer asks you to tell me everything, you don't. Your response should be, "That's a very broad question. Could you be more specific?" Or, "Where would you like me to begin?" Force them to do their job. Make them ask specific, pointed questions. Never ever volunteer information. Your job is not to tell a story. Your job is to answer the question that is asked, and only the question that is asked, and then stop talking. After David had exhausted himself telling his story, the lawyer moved to the second trap, the assumptive close. He leaned forward and said, "So, after you realized the project was going to miss its deadline, what steps did you take to inform the client?" David's mind went blank for a second. The question sounded reasonable, but there was a hidden bomb inside it. The phrase, "after you realized the project was going to miss its deadline." David never said that. In his mind, he never believed the project was going to miss its deadline. He was working to fix the very issues that were causing the delay. But the question assumed it as a fact. If David answers the second part of the question, "What steps did you take?" he implicitly agrees with the first part. He's just admitted on the record under oath that he knew the project was doomed. If he says, "Well, I called Mr. Smith," the lawyer will write down, admits he knew project would miss deadline, then called Smith. It's a classic bait and switch. David, flustered, started to stammer. "Well, I didn't necessarily realize it was going to miss the deadline. I was just too late." He was defensive. He was explaining. He had lost control. The correct response is to dismantle the trap before you even touch the bait. You have to listen to every single word in a question. When you hear a false premise, you stop. You do not answer the question. You correct the premise. The power move here is to say, calmly and clearly, "I disagree with the premise of your question. I never came to the realization that the project was going to miss its deadline." And then you stop. You wait. You force the lawyer to re-ask the question properly. "Did you ever believe the project was going to miss its deadline?" "No." "Did you take steps to inform the client about delays?" "Yes." You have now separated the lie from the truth. You've taken back control. Next, the lawyer deployed the third classic weapon, the compound question. He asked, "Isn't it true that you received the revised budget on May 5th, and you failed to send it to your supervisor for approval?" Listen to that again. Sounds like one question, but it's two. 1. Did you receive the revised budget on May 5th? 2. Did you fail to send it to your supervisor? David's brain short-circuited. He had received the budget, but he had sent it to his supervisor. If he answers no, is he denying he received it? If he answers yes, is he admitting he failed to send it? Either way, he's trapped. He's being forced to confirm a half-truth that will be recorded as a whole lie. This is a deliberate tactic to confuse you and corner you into a simple yes or no that misrepresents the facts. The average person under pressure will try to answer the whole thing at once. "No, that's not right, I got it and I sent it." And they start rambling, looking defensive and untrustworthy. The pro move? You are the one in charge of your answers. You recognize the trap and you refuse to step in it. You calmly say, "That's 2 questions. Which one would you like me to answer first?" Boom. The power has just shifted back to you. You've exposed the lawyer's trick. You've demonstrated that you are paying close attention, that you are precise, and that you will not be manipulated. The lawyer now has to break it down. "Okay, fine. Did you receive the revised budget on May 5th? "Yes." "And did you send it to your supervisor for approval?" "Yes, I did." You have answered truthfully, precisely, and you have given them absolutely nothing extra to use against you. These 3 traps, the narrative, the assumptive close, and the compound question, are the bread and butter of a deposition lawyer. They are designed to exploit our natural human tendency to be helpful, to tell our story, and to engage in normal conversation. But a deposition is not normal. It's a highly artificial, high-stakes environment where every word matters. Understanding these basic traps is your first layer of armor. But these are just the opening moves. The real psychological warfare begins when the lawyer starts to probe not just what you did, but what you were thinking. The most dangerous questions of all aren't about facts and timelines. They are the questions that crawl inside your head, the ones that seem simple, almost philosophical, but are designed to utterly destroy your credibility. They are the questions that start with a single, devastating 3-letter word. Why? That's it. That's the word. Why? It sounds so innocent, doesn't it? It's a question of curiosity. A question a child asks 100 times a day. In a deposition, it is pure poison. It is the most skillfully crafted, psychologically devastating weapon in a lawyer's arsenal. Because the question why is never, ever a request for facts. It is an invitation to speculate. It is a demand that you justify your actions. It is a trapdoor that drops you from the solid ground of what happened into the bottomless pit of your own mind, your motivations, your beliefs, your feelings, your judgments. And in that pit, the opposing lawyer is king. Let's play this out. You're in a simple car accident case. You were making a left turn on a green arrow. The other car ran a red light and hit you. Seems straightforward. The opposing lawyer asks, Why did you proceed to turn when you did? What's your natural human response? You want to explain yourself. You'll say something like, well, I turned because the arrow was green and I thought I had plenty of time. The road looked clear, and I felt it was safe to go. And just like that, the trap has sprung. You may as well have handed the lawyer a signed confession. Because what did you just do? You didn't state facts. You stated opinions, thoughts, and feelings. Let's break down your answer. You said, I thought I had plenty of time. The lawyer's follow-up. So you weren't sure? You were guessing? How do you define plenty of time? 5 seconds. 10. Did you time it? No. So it was just a gut feeling, is that right? A feeling that turned out to be wrong. You said, the road looked clear. The lawyer's follow-up. Looked clear? But obviously it wasn't clear, was it? Since my client's car was there. So your observation was inaccurate. Were you not paying close enough attention? Where exactly were you looking? Were you looking left? Right? At your radio? You say it looked clear, but you didn't actually see that it was clear. You said, I felt it was safe to go. The lawyer's follow-up. You felt it was safe? This wasn't a decision based on facts, but on a feeling? We all have feelings, but feelings can be wrong, can't they? And in this case, your feeling was dead wrong and it caused a serious accident. Is that fair to say? In the space of 30 seconds, you went from being the victim of a red light runner to a reckless driver who operates on guesses, inaccurate observations, and unreliable feelings. Every word you used to justify yourself has been twisted into a weapon and used against you. You have been forced to defend your internal thought process, something that is impossible to do, especially under pressure and with the benefit of hindsight. So what do? How do you answer the deadliest question in a deposition? You follow a simple but powerful rule. You do not answer why. You answer what? You transform the question. You refuse the invitation to speculate, and you stick to the unshakable, observable facts that informed your actions. Let's rewind. The lawyer asks, why did you proceed to turn when you did? You take a breath. You pause. You reject the premise of the question in your mind. He's not asking for your state of mind. He's asking what facts you observed. Your new answer. The traffic signal for my lane of travel was a green arrow. That's it. Stop talking. Look at the power of that answer. It is 100% factual. It is verifiable. It is impossible to attack. What can the lawyer say? Are you sure it was green? Yes. The ball is back in his court. He is now forced to ask you factual questions, which is exactly where you want to be. He'll have to ask, what did you see? I saw a green arrow. What did you do? I proceeded to make my turn. Did you see any other vehicles? No, I did not. You are a human lie detector, reporting only what your senses registered. You are not a philosopher explaining your worldview. By answering the what instead of the why, you give the lawyer nothing to attack. You are building a fortress of facts brick by brick, while he's trying to lure you into a swamp of speculation. This principle extends beyond the word why. Lawyers have a whole family of these psychoanalytical questions. They are all cousins of why, and they are all just as dangerous. Be on high alert for questions that start with, what was your understanding of the situation? This isn't about facts. It's about your interpretation, which could have been flawed. What did you believe was going to happen? This is a request for you to predict the future, to state a belief that was proven wrong. What was your intention when you sent that email? Your intention is irrelevant. What matters is what the email actually says. Wouldn't you agree that? This is a classic trick to get you to adopt the lawyer's characterization of events, and the whole family of hypotheticals. Could you have waited longer? Should you have double-checked the report? If you had known X, you would have done Y, correct? All of these are why questions in disguise. They are designed to pull you away from what you did, what you saw, and what you heard, and push you into the realm of opinion, judgment, and regret. Your defense is always the same. Pause. Mentally reframe the question into a request for facts. Then, state only the facts you knew at that specific moment in time. Let's try a different scenario. A workplace dispute. A manager is being deposed about firing an employee. The lawyer asks, what was your understanding of Mr. Jones's attitude problem? Bad answer. My understanding was that he was negative, he wasn't a team player, and he was dragging down morale. This is all opinion. It's vague and subjective. The lawyer will spend the next hour forcing you to define negative, team player, and morale. Good answer. I can tell you what I observed. On May 5th, I heard Mr. Jones tell a coworker that the new project was a stupid waste of time. On May 12th, during a team meeting, he rolled his eyes when a colleague was speaking. On May 18th, he was issued a written warning for insubordination. Facts, observations, documented events, indisputable. The lawyer asks, "Why did you feel you had to fire him on that specific day?" Bad answer. "Because I'd had enough. It was the last straw, and I felt like I had to make a change for the good of the team." Feelings, justifications. The lawyer will feast on this. What does "had enough" mean? Were you angry? Did you lose your temper? Good answer. That morning I reviewed his final performance review, which was submitted by his direct supervisor. I also consulted the company's 3-strike disciplinary policy. Based on those documents in that policy, I made the decision. Process, policy, documents. There is no emotion here. There is no why. There is only what happened. If you are ever truly stumped, if a lawyer is relentlessly pushing you to explain your state of mind from 3 years ago, you have a final ultimate defense. It's 3 simple, honest words. I don't recall. What were you thinking in that exact moment before you signed the contract? I don't recall my specific thought process. I recall reading the document and then signing it. What was your primary motivation for choosing vendor A over vendor B? I don't recall my exact motivation. I do recall reviewing the proposals from both vendors and concluding that vendor A met the criteria outlined in the project charter. I don't recall is not a lie. You almost certainly do not remember the precise, fleeting thoughts that went through your head years ago. What you remember are the facts and the actions. Stating "I don't recall my thought process" is honest, it's accurate, and it completely shuts down the lawyer's line of questioning. It is a brick wall. Mastering your response to these psychological questions is one of the most critical skills for surviving a deposition. It is the art of staying out of your own head. The lawyer wants to make your mind the central issue of the case. Your job is to make the facts the central issue, because facts are stubborn, facts are defensible. Your feelings, beliefs, and thoughts from 2 years ago, they are clouds that a skilled lawyer can shape into anything they want. But this isn't just about the words you say. It's also about the silence in between. The lawyer's greatest tactical advantage isn't just what they ask, but how they control the very rhythm of the room. They use silence not as an absence of sound, but as a psychological tool, a form of pressure designed to make you uncomfortable, to make you nervous, to make you talk. And when you talk to fill a void, you almost always say something you will come to regret. They have a name for this tactic, and learning how to defeat it is the next crucial step in your survival. It's called the pregnant pause, and it is one of the oldest, simplest, and most devastatingly effective psychological weapons in a trial lawyer's arsenal. It's not a trick of law, it's a trick of human nature. We are social creatures hardwired over millennia to seek connection, to avoid awkwardness, and to fill conversational voids. Silence in a normal conversation often signals confusion, disagreement, or a need for more information. So, when someone stops talking, our natural, deeply ingrained instinct is to jump in and help, to clarify, to elaborate, to keep the social gears turning. The opposing lawyer knows this. They are counting on it. They will use your own social conditioning against you to build their case. Let's paint a picture. You're in that sterile conference room. The air conditioner hums. The only other sound is the quiet, rhythmic tapping of the court reporter's fingers on their steno machine. The lawyer across the table looks at you. Their face a neutral mask. They ask a simple, straightforward question. Where were you on the night of March 15th? You've prepared for this. Your lawyer told you to be truthful and direct. So you answer, I was at home. And then nothing. The lawyer doesn't move. They don't ask a follow-up question. They just hold your gaze. Maybe they slowly pick up a pen and make a tiny, meaningless note on a yellow legal pad. 1 second passes. Then 5. The silence in the room starts to feel heavy, like a physical weight pressing down on you. 10 seconds. The court reporter's hands are still, poised over the keys. Your own lawyer is quiet, watching. 15 seconds. The silence is no longer just an absence of sound. It has become a statement. It's a weaponized void, a conversational black hole, and it is pulling you in. Your mind starts racing. Did I answer that wrong? Was at home not enough? It sounds suspicious, doesn't it? Just at home. A guilty person would say that. I should explain. I should give them more. It'll show I have nothing to hide. So you break. You hear your own voice, sounding a little too loud in the quiet room. I mean, I was at home, watching a movie with my wife. It was that new action movie, I can't remember the name of it. We ordered a pizza around 7:30. Pepperoni and mushroom. I think I have the receipt in my email somewhere if you need it. I was on the couch the whole night pretty much, until we went to bed around 11. And just like that, the trap has sprung. The lawyer gives a slight, almost imperceptible nod, and finally jots down a real note. You feel a wave of relief. You filled the silence. You clarified your answer. You were helpful. But what did you actually do? You took a simple, complete, and truthful answer. I was at home. And you single-handedly, without any prompting, gave the opposing counsel a dozen new avenues of inquiry. Who is your wife? What's her name? Will she need to be deposed now to confirm your story? What was the name of the movie? What service did you watch it on? Can you produce records? What pizzeria did you order from? What time was the order placed? What time was it delivered? Can you produce the credit card statement or the email receipt? You said you went to bed around 11. What does around mean? Was it 10:45? 11:20? Could you have left the house after your wife fell asleep? You see, your desire to be helpful and to escape the discomfort of silence just handed the other side a roadmap to dissect your life, to poke holes in your memory, and to potentially catch you in a minor, meaningless inconsistency that they can later blow up at trial to make you look like a liar. An inconsistency about the topping on a pizza could be used to question your credibility about the central facts of the case. All because you couldn't tolerate 15 seconds of quiet. Defeating the pregnant pause is not about being clever. It's about discipline. It requires you to fight against your most basic human instincts. It requires a 3-step mental process that you must burn into your brain. First, answer the question that was asked and only the question that was asked. Be truthful. Be direct. And then, most importantly, stop talking. Physically close your mouth. Your job is done. You have provided the information that was legally requested. Period. Second, embrace the silence. This is the hardest part. You must learn to become comfortable with being uncomfortable. When the lawyer stares at you, waiting for you to crack, you must stare back. Not in an aggressive or challenging way, but in a calm, patient, and neutral way. Your calm demeanor sends a powerful message. My answer is complete. I am confident in that answer. I have nothing to add and nothing to hide. It is now your turn to speak. I can wait all day. Think of it as a game of poker. The lawyer's silence is a bluff. They are acting like your answer was insufficient, hoping you'll get nervous and sweeten the pot by throwing in more information for free. By staying silent, you are calmly calling their bluff. You are refusing to show them any more of your cards until they ask to see them. You are shifting the pressure and the awkwardness from your shoulders right back onto theirs. They created the silence. It is their responsibility to fill it with another question. Third, use your tools. Take a slow, deliberate sip of water. This is a classic for a reason. It gives you a physical action to perform, it breaks the lawyer's eye contact for a moment, and it reinforces in your own mind that you are in control of your own pacing. You can also look briefly at your own lawyer. Their calm presence will be a reassuring anchor, reminding you that you are not alone, and that you are executing the game plan correctly. What if the silence goes on for an unreasonably long time? A full minute or even more? This is rare, as it starts to look like pure intimidation, but it can happen. If you feel the need to say something, do not volunteer new information. Instead, you can ask a simple, polite, clarifying question that puts the ball back in their court. Something like, "Is there a question pending?" Or, "Have I fully answered your question?" This shows you are alert, engaged, and unflustered, while politely prompting them to do their job and move on. Your own lawyer is your primary defense here. They know this tactic well. Part of their job is to protect you from harassment. If the opposing counsel's use of silence becomes excessive and feels more like a staring contest than a legal proceeding, your lawyer will and should step in. They might say, "Counsel, the witness has answered your question. Do you have another, or shall we take a break?" This is their role, to be your shield. Mastering the silence is more than just a defensive tactic. It's a fundamental shift in mindset. It's the moment you realize that the deposition is not a conversation. It's not a chat. It is a formal, strategic, and adversarial process where every single word matters. The opposing lawyer is not your friend. They are not trying to understand your story. They are mining for data points, facts, admissions, inconsistencies, and emotional triggers that they can use to damage your case. By volunteering information to fill a silence, You are essentially grabbing a shovel and helping them dig. Don't do their job for them. Answer the question. Stop talking. Breathe. Wait. This simple disciplined act is one of the most powerful things you can do to protect yourself. It demonstrates confidence, control, and an understanding of the rules of the game. But the pregnant pause is just one type of psychological trap. Lawyers have a whole playbook of confusing, misleading, and cleverly worded questions designed to trip you up. These are the verbal landmines of a deposition. Learning to spot them is critical. They can be subtle, wrapping a false assumption in a seemingly innocent question, or they can be complex, forcing you into a yes or no that doesn't fit the truth. Navigating this minefield is our next priority, and it begins with learning to recognize the most common forms of trick questions before you ever take a step into that room. Let's arm you with the knowledge to spot these traps from a mile away. Think of the opposing counsel not as a person, but as a predator with a specific set of hunting techniques. They use these over and over because they work. Your job is to recognize the technique, refuse the bait, and wait for a question you can answer truthfully and safely. The first and most common trap is the compound question. This is the classic 2 for the price of 1 trick. The lawyer will bundle 2 or more questions together, often linking a simple true statement with a damaging false one. For example, in a car accident case, they might ask, "So you were looking at your GPS and ran the red light, correct?" See the trap? Maybe you were looking at your GPS for a split second, but you are certain the light was yellow, not red. But the question forces you into a single yes or no. If you say yes, you've just admitted to running a red light. You've handed them a confession. If you say no, you might be lying about looking at your GPS, and if they can prove you were, your credibility is now shot. You look like a liar. You lose either way. The defense is simple but requires you to be vigilant. You must mentally slice the question into its individual parts. When you hear a compound question, you can say, "That's actually 2 questions. Which one would you like me to answer first?" Or more directly, "I can answer that if you break it down into separate questions." This does 2 things. First, it shows the lawyer you can't be pushed around. You're not a novice. Second, it forces them to ask the questions one by one, allowing you to answer each part accurately. Were you looking at your GPS? For a moment, yes. Did you run the red light? No, the light was yellow. See the difference? You've answered truthfully without falling into the trap. Next on the list is the loaded question, also known as the assumptive question. This is more insidious. This question contains a built-in, unproven assumption, and it's designed to make you look bad no matter how you answer. The classic example is, "Have you stopped beating your wife?" Answering yes implies you used to. Answering no implies you still do. In a deposition, it'll be more subtle. "How much did you drink at the bar before you got behind the wheel?" This question assumes you were drinking at the bar. If you weren't, answering 3 beers or even none can be tricky. Answering none makes it sound like you're just denying the amount, not the premise of being at the bar drinking. The proper defense here is not to answer the question at all. You must first attack the false premise. Your response should be a firm rejection of the assumption. Your question assumes I was drinking at the bar, which is incorrect. I was not. Or if your lawyer is on the ball, they'll object, saying, "Objection," assumes facts not in evidence. But you cannot rely on your lawyer to catch everything. You are your own first line of defense. Recognize that the question itself is a lie, and call it out. Do not legitimize a false assumption by engaging with it. Then we have the hypothetical question. These often start with "what if," "wouldn't you agree that," or "is it possible that." The lawyer is trying to pull you out of the world of what did happen and into the speculative world of what might have happened. This is a minefield. They'll ask something like, "If you had been paying closer attention, is it possible you would have seen the other car sooner?" Seems harmless. Of course it's possible. But saying yes is a disaster. You've just admitted you weren't paying close enough attention. You've created a hypothetical scenario where you are at fault, and the court reporter is typing every word. Your defense against hypotheticals is to live by one simple rule. I only testify to what happened. That's it. Your answer should be a polite but firm refusal to play their game. I'm not going to speculate on what might have happened. I can only tell you what I saw and what I did. Or simply, I can't answer that. It's a hypothetical. This is a perfectly acceptable and powerful response. You are there to be a witness to history, not to write fiction for the opposing counsel. Stick to the facts. Now let's flip the script. Sometimes the trap isn't a tricky, narrow question, but one that is deliberately broad and open-ended. This is the narrative question. The lawyer will lean back, smile, and say something like, "Okay, just tell me in your own words what happened on the day of the incident." This feels like a relief. Finally, a chance to tell your story. It is a trap. It is the most dangerous trap of all for the unprepared. They are inviting you to talk and talk and talk. And the more you talk, the more likely you are to say something you shouldn't. You'll volunteer information they never would have thought to ask for. You'll mention names of people they can now depose. You'll give long, rambling answers that they can pick apart later, finding tiny inconsistencies to make you look like a liar. They are handing you a shovel and hoping you'll dig your own grave. The countermove is to resist the urge to narrate. Answer the question they asked, but do it in the most concise, factual way possible. If they say, "Tell me what happened that day," you provide a bare-bones timeline. "I woke up. I went to work. I attended a meeting at 10 a.m. I left work at 5 p.m. The collision occurred at 5:15 p.m. That's it. You stop talking. This forces them to do their job. It forces them to ask specific, follow-up questions. What was discussed at the 10 a.m. meeting? Where were you going at 5:15? You have now taken back control, turning their open-ended trap into a series of specific questions you can answer carefully, one at a time. Finally, beware the slow burn tactic of the leading question with a confirmation tag. These are statements disguised as questions, ending with a little hook like, "Isn't that right? Correct?" Or, "Wouldn't you agree?" The lawyer builds a rhythm, getting you to agree to a series of simple, undeniable truths. "You were driving a blue sedan, correct?" "Yes." "And the road was wet, right?" "Yes." "Visibility was poor, wasn't it?" "Yes." "And you were in a hurry to get home, isn't that true?" "Yes." Then comes the kill shot. "So you would agree that driving over the speed limit under those conditions was reckless, wouldn't you?" They've walked you down a path of yes, conditioning you to be agreeable, and then they slip the knife in. The defense is to break the rhythm. You must treat every single question, no matter how simple, as a brand new standalone inquiry. Pause before you answer. Think, is the statement 100% accurate as stated? Maybe the road wasn't wet. Maybe it was just damp in patches. Maybe visibility wasn't poor. It was just overcast. Correct the premise before you answer. It was overcast, but visibility was still good. Don't let them put words in your mouth or summarize your testimony for you. You are in charge of the words that come out of your mouth. Recognizing these 5 patterns, the compound, the loaded, the hypothetical, the narrative, and the leading question, is like being given a decoder ring for the enemy's playbook. But spotting the trap is only half the battle. The other half is how you conduct yourself, the image you project, and how you use the single most powerful tool you have in that room, silence. Mastering your own demeanor under fire is what separates the victims from the survivors. Let's start with the basics of your physical presence. The moment you walk into that room, you are being evaluated. The opposing counsel is watching how you sit, how you hold your hands, where your eyes go. This isn't paranoia. It's their job. They're trying to get a read on you. Are you nervous? Evasive? Arrogant? Confident? Every little twitch and gesture is a piece of data they will try to use against you. Your mission is to give them absolutely nothing. Sit up straight in your chair. Not ramrod straight like a soldier at attention, but with a posture that conveys alertness and confidence. Slouching signals disinterest, weakness, or even dishonesty. Leaning too far forward can seem aggressive. Find a neutral, comfortable, upright position. Place your hands on the table in front of you. You can lightly clasp them or rest one on top of the other. Do not fidget. Don't click a pen, tap your fingers, or wring your hands. Fidgeting is a universal sign of anxiety, and in a deposition, anxiety can be misinterpreted by the other side as a sign you're about to lie. Stillness is strength. Your eye contact is a critical instrument of control. When the opposing lawyer asks you a question, look directly at them. Not a hostile glare, but a calm, steady gaze that says, "I am here, I am listening, and I am not afraid of you." When you deliver your answer, continue to look at them. Do not let your eyes dart around the room. Do not look down at your hands or at the floor. In our culture, looking away while speaking is often perceived as a sign of deception. You are there to be a beacon of truth and credibility. Your eye contact reinforces that. It projects sincerity and confidence. Your facial expression should be as neutral as possible. Think of it as your deposition poker face. The other lawyer will ask questions designed to provoke an emotional reaction. They might ask insulting questions, mischaracterize your past statements, or bring up painful memories. Do not give them the satisfaction of a reaction. No eye-rolling, no sighing, no shaking your head in disgust, no smirking. Any emotional display is a crack in your armor, a piece of information they can use. They learn what pushes your buttons. If you get angry, they know they've found a sensitive area and they will dig deeper. By remaining placid and neutral, you communicate that their psychological games have no effect on you. You are a calm, factual witness, and their attempts to rattle you are a waste of time. This is incredibly frustrating for an attorney who relies on emotional leverage. Now let's talk about the single most important technique you will use, the strategic pause, the power of silence. Before you answer any question, and I mean every single question, even, can you state your name for the record? You must pause. Take a deliberate 2 to 3 seconds. This will feel unnatural. It will feel awkward. The opposing lawyer wants to build a rhythm, a rapid-fire back and forth that gets you talking quickly without thinking. Your pause shatters that rhythm. It puts you in control of the pace of the entire proceeding. This pause serves 3 crucial purposes. First, it gives you time to truly hear and understand the question. Was it a compound question with 2 parts? Did it include a subtle assumption that isn't true? Is it vague or ambiguous? You cannot give a truthful, accurate answer to a question you haven't fully processed. The pause is your brain's processing time. Second, the pause gives you time to formulate your answer. Your goal is to be precise, concise, and truthful. The pause allows you to mentally draft your response, stripping away any unnecessary words, any speculation, any emotional commentary. It helps you deliver just the facts, without accidentally volunteering extra information that could hurt your case. It's the difference between saying, "Yeah, I saw the red car run the light because I was looking that way after I got off a really stressful phone call with my boss, and was just trying to clear my head," versus pausing and simply saying, "Yes." One answer is a goldmine for the other lawyer. The other is a brick wall. The third reason for the pause is most critical from a legal standpoint. It creates a space for your attorney to object. If the opposing counsel asks an improper question, one that calls for hearsay or is protected by privilege or is designed to harass you, and you blurt out an answer immediately, you may have waived your right to an objection. The answer is already on the record. That 2 to 3 second pause is a nonverbal signal to your lawyer. It says, "I am about to answer this question. If you have a problem with it, now is your time to speak up." It's a team play, and it protects you from legal traps you might not even see. Embrace the silence. It will make the other lawyer uncomfortable. They live in a world of words, and a vacuum of sound can be unnerving. They might rush to fill the silence by rephrasing the question, and in doing so, they might simplify it or reveal the angle they're pursuing. Let them. Your silence is a tool of immense power. It projects thoughtfulness, confidence, and control. Your tone of voice is another key component of your demeanor. Speak in a calm, measured, and clear voice. You don't need to be a robot, but you should avoid emotional extremes. Do not raise your voice in anger or frustration, no matter how provocative the questioning becomes. Do not whisper or mumble, which can suggest a lack of confidence. You need to speak clearly so the court reporter can accurately transcribe every word. And absolutely, under no circumstances, should you use sarcasm or try to be funny. A sarcastic "of course I'd remember that" will be written in the transcript as "of course I'd remember that." The sarcasm is lost, and what remains is a statement of fact that can be used against you. Your goal is to be the most boring, straightforward, and credible witness they have ever encountered. Combine these elements: the steady posture, the direct eye contact, the neutral expression, the measured tone, and the all-powerful pause, and you transform yourself. You are no longer just a person answering questions. You become a fortress. The opposing counsel's objective is to find a way inside, to find a weak spot, an emotional trigger, a moment of confusion they can exploit. When you present yourself as a calm, impenetrable fortress of fact, their psychological tools become useless. They are left with nothing but the facts of the case, which is exactly where you want them to be. This display of composure does more than just get you through the day. It sends a powerful message. It tells the other side that if this case goes to trial, you will be a composed, credible, and unshakable witness in front of a jury. That realization alone can dramatically shift the dynamics of settlement negotiations in your favor. By mastering your demeanor, you build the walls of your fortress. But the most clever attorneys won't try to knock down the walls. They'll try to trick you into opening the gate for them. They do this with specific, carefully crafted questions designed to trap you. And in the next part, we're going to dissect every single one of those traps. Let's start with the most common and deceptively simple trap, the compound question. This is when the lawyer bundles two, sometimes three separate questions into one sentence, hoping you'll answer with a single yes or no. For example, on the morning of the accident, were you running late for your meeting and looking at your phone? See what they did? That's not one question. It's two. Were you running late? Were you looking at your phone? If you say yes, you've just admitted to both under oath. You've admitted to being distracted and rushed. If you say no, it's ambiguous. No to which part? The lawyer will later twist that ambiguity, saying, well, you denied looking at your phone, but you didn't deny you were running late, did you? It's a verbal shell game. The defense is simple, but it requires you to be listening actively. You stop, you pause, and you say, that sounds like two separate questions. Which one would you like me to answer first? Boom. You've just disarmed the trap. You've shown them you're paying attention, and you will not be hurted. You are forcing them to play on your terms, one simple fact at a time. Next up is the cousin of the compound question, something even more insidious, the assumptive question. This is a question that contains a hidden, unproven assumption. The classic law school example is, have you stopped beating your wife? Answering yes or no admits to the premise that you were beating your wife. In a real deposition, it's more subtle. The lawyer might ask, after you ran the stop sign, where did you go? But wait a minute. You never testified that you ran the stop sign. They just slipped it in there, assuming it is fact. If you answer the question and say, I went to the grocery store, you have just implicitly agreed that you ran the stop sign. You fell for it. Your mind was so focused on answering the end of the question that you accepted the poison pill at the beginning. The defense here is to attack the premise. You don't answer the question at all. You correct the record. You say, I disagree with the premise of your question. I did not run the stop sign. You must tear down the faulty foundation before they can build a case on it. Never, ever let a false assumption in the lawyer's question go unchallenged. Now for a trap that preys on our desire to be agreeable and certain. The absolute question. These are questions that use words like always, never, every time, or all. For example, do you always use your turn signal when changing lanes? Or have you never gone over the speed limit on that particular highway? These are perjury traps, plain and simple. Because in life, very few things are absolute. If you say, yes, I always use my turn signal, you better be a saint. Because all that lawyer has to do is find one person, one witness, one traffic camera from your entire driving history to prove you wrong just once. And if they can, they won't just say you made a mistake. They will stand up in front of a jury and say, this person sat here under oath and lied to you. They told you they always do something and we have proof they don't. If they lied about this small thing, what else are they lying about? You see how dangerous that is? The defense is to refuse the absolute. You qualify your answer. You say, it is my habit and practice to use my turn signal. Or, I can't speak in absolutes like always or never. I can only tell you what I did on the day of the incident. You bring them back from the hypothetical universe of always, and ground them in the specific reality of the case. This leads directly into the next trap, the speculative question. This is when the lawyer asks you to guess, to assume, or to read someone else's mind. What do you think the other driver was thinking right before the crash? If you had been driving a different car, do you think the injuries would have been less severe? Could you have stopped sooner? Your opinion on what might have been is irrelevant. Your guess about someone else's state of mind is worthless. You are there to testify about facts, what you saw, what you heard, what you did. You are not a psychic. You are not an accident reconstruction expert. When you speculate, you are giving them free ammunition. Your guess, spoken under oath, can be twisted into a statement of fact. The defense is one of the most powerful phrases you can use in a deposition. I don't know, or, I can't speculate. Don't be afraid to say it. It's not a sign of weakness. It's a sign of precision. You are refusing to build a fantasy world for the lawyer to play in. You say, I can't know what the other driver was thinking. I can only tell you what I saw his car do. You are a witness to history, not an author of fiction. Finally, we have the most exhausting and dangerous trap, usually deployed late in the day when you're tired and your guard is down, the misleading summary. The lawyer will lean back, smile, and say something like, okay, let me see if I've got this right. You testified that you were a little tired, you were going about 10 miles over the speed limit, and you only glanced at the light before going through the intersection. Is that a fair summary? Sounds plausible. It sounds mostly like what you said, but they've twisted it. You said you were fine. They changed it to a little tired. You said you were going the speed limit. They changed it to 10 miles over. You said you looked at the light and it was green. They changed it to glanced at the light. They are trying to get you to co-sign their version of events. And if you're fatigued and you just nod and say, yeah, that's about right, you have just adopted their false narrative as your own sworn testimony. It's devastating. The defense requires your absolute, unwavering attention, especially at the end of the day. You must listen to every single word of their summary, and if even one word is wrong, you correct it firmly. No, that is not an accurate summary. As I stated before, I was not tired. I was traveling at the speed limit, and I clearly saw the light was green. You do not let them put words in your mouth. You do not let them rewrite your history. These 5 traps, the compound, the assumptive, the absolute, the speculative, and the misleading summary, are the primary weapons an opposing lawyer will use against you. They are not designed to find the truth. They are designed to create a version of the truth that benefits their client. Recognizing them is the first step. Disarming them with the phrases and techniques we've just discussed is how you protect yourself. But knowing the questions is only half the battle. The other half is about how you conduct yourself, the unwritten rules of the room, and the psychological game that plays out beyond the questions themselves. So let's talk about the room. Let's talk about the atmosphere. Because when you walk into that conference room and sit down at that long polished table, you are stepping onto a stage. And on this stage, you need to play a very specific role. I call it the deposition persona. This isn't about being fake or dishonest. It's about being disciplined. Your normal everyday personality, the one that's helpful, friendly, and likes to fill awkward silences, that person needs to wait outside. The person who sits in that chair is precise, patient, and unemotional. Think of a bomb disposal expert. They don't rush. They don't guess. They don't get flustered. They focus only on the wire directly in front of them. Every question is a wire. You examine it, you address it, and you move on. The first and most powerful tool the opposing lawyer will use against your everyday personality is silence. It is the single most effective, low-tech weapon in their entire arsenal. It works like this. The lawyer asks you a simple question. What color was the traffic light? You answer, it was red, and then nothing. The lawyer just looks at you. They don't write anything down. They don't ask the next question. They just hold your gaze. A silence that started as 1 second stretches into 3, then 5. It becomes heavy. Your brain, conditioned by a lifetime of normal conversation, starts to panic. It screams, did I say something wrong? Was that not enough? Maybe I should explain why I know it was red. Maybe I should add that I was looking right at it, that the sun wasn't in my eyes, that I had just taken a sip of coffee. Your instinct is to fill that silence, to help, to elaborate. Do not do it. This silence is a trap. It's designed to make you uncomfortable, to make you second-guess your own simple, truthful answer. The lawyer is baiting you to volunteer information. They want you to ramble, because in that ramble, you might say something inconsistent. You might give them a new thread to pull, a new line of questioning you and your lawyer never even considered. Your job is to resist this urge with every fiber of your being. Give your short, honest answer, and then stop. Embrace the silence. Make it your friend. If the lawyer wants to sit there in a staring contest for 5 minutes, let them. It's their time, their client's money. You are getting paid for your time. Sit there, breathe calmly, and wait for the next question. You have answered. Your work is done. This single skill, the mastery of silence, will frustrate the opposing attorney more than you can possibly imagine. The second psychological game is the opposite of silence. It's the friendly lawyer routine. Some lawyers are sharks and they look like sharks. They're aggressive, they interrupt, they try to intimidate you. But others are far more dangerous. They come in smiling, offer you a coffee, and ask about your kids. They'll say things like, look, Sarah, I'm just trying to understand what happened here. We're all just people trying to get to the bottom of this. They create a relaxed, conversational atmosphere. They want you to feel like you're just having a chat with a reasonable person. This is the most insidious trap of all. When you feel relaxed, you let your guard down. You start talking to them like you would a neighbor over the fence. You start to volunteer stories, to offer context, to help them understand. You forget that this friendly person's one and only job is to find ways to destroy your credibility, and make your case worthless. Their goal is to get you to say anything that can be used against you later. Remember, this is not a conversation. It is a formal sworn testimony in an adversarial legal proceeding. That person is not your friend. Be polite, be civil, but do not be friendly. Maintain your deposition persona. Be the calm, careful, precise witness. Answer their questions the same way you would answer the aggressive lawyers, truthfully, and with as few words as possible. Now, this mental discipline is hard to maintain for hours on end. That's why you have to control your physical state. This starts the night before. Get a full night's sleep. A tired brain makes mistakes. On the morning of the deposition, eat a solid breakfast. Not a sugary donut that will cause you to crash, but something with protein that will give you sustained energy. And be very, very careful with caffeine. If you're a regular coffee drinker, have your normal amount. But don't drink 3 extra cups out of nervousness. You'll be jittery, anxious, and more likely to talk too fast and say too much. Dress comfortably but professionally. You don't want to be fidgeting with an itchy collar or shoes that are too tight for 6 hours. Your physical comfort directly impacts your mental endurance. And during the deposition, remember you have a lifeline sitting right next to you, your own lawyer. They are not just there for decoration. You and your lawyer should have a system. Maybe it's a subtle signal, or maybe it's just the understanding that you will pause and look at them before answering any question that seems confusing or tricky. Listen to their objections. If your lawyer says objection form, that's a signal to you. It means there's something wrong with how the question was asked. It might be confusing or compound, or assume facts not in evidence. When you hear an objection, stop. Do not try to answer. Listen to the lawyer sort it out. Your lawyer will then tell you if you should answer it. More importantly, your lawyer is your key to taking breaks. A deposition is a marathon of mental focus. No one can maintain perfect concentration for hours without a reset. The other side knows this. Sometimes they will intentionally push you, hoping to get you to a point of fatigue where you make a crucial error. You have the right to ask for a break at any time for any reason. You don't have to wait for the scheduled lunch break. If you feel tired, overwhelmed, or confused, or if you just need to use the restroom, turn to your lawyer and say, "I'd like to take a break." You don't ask the other lawyer, you tell your lawyer. This is a power move. It shows you are in control of your own pacing. During that break, you can confer with your attorney privately. You can ask, "How am I doing?" Or "What did they mean by that last line of questioning?" It's a strategic timeout to reset, refocus, and get guidance. Do not be a hero and try to power through. Use your breaks. This brings us to the end of the day. You're tired. You've been answering questions for hours. Your brain feels like mush. And then the opposing lawyer leans back, smiles a little, and asks the final, most dangerous question of the day. Sounds completely innocent. They'll say something like, "Okay, I think we're just about done here. Is there anything else you'd like to add? Anything at all that we haven't covered that you think is important?" Your entire being will want to unload. You'll think, "Yes, finally, my chance to tell my side of the story. They didn't ask me about the most important part." You'll want to clarify an answer you gave 3 hours ago that you've been stewing over. You will be tempted to give a speech to make sure they really understand. This is the final ultimate trap. It is a wide-open invitation to destroy your own case. Never ever take the bait. If you add new information, the lawyer is not going to pack up and go home. They are going to say, "Oh, that's interesting. Let's talk about that." And you've just opened up another 2 hours of questioning on a topic you introduced, potentially without any preparation with your own lawyer. The correct answer to, "Is there anything else you'd like to add?" is a simple, polite, and firm, "No." Or if you want to be slightly more thorough, "Not that I can recall at this time." You have done your job. Your job was not to tell your whole story. Your job was to truthfully answer the questions that were asked. Nothing more. By understanding these unwritten rules, by adopting the right persona, mastering silence, recognizing false friendship, and using your attorney and your breaks strategically, you transform from a potential victim of the process into an active, controlled participant. You take away the other side's power and put yourself in the driver's seat.